Hi, Crime Junkie Jurors. Good morning. Good morning. Hello. It is April 9th, 2025. We are now in jury selection day 7 for Karen Reed's second trial. Good morning. Yes, Bev's burner phone, you are on it, doggone it. We have 12 jurors as of yesterday. We need 4 more. So right now we have enough to deliberate, but of course we need alternates. That was an abrupt start. I know all of y'all are used to the intro music and stuff from the other channel, but we're working on something. Good morning. Good morning. Okay, so yesterday, if you missed the recap, happy hump day. Happy hump day. If you missed the recap yesterday, there were 47 in the jury pool. Yes. Well, technically there were 48. So there were 48 that showed up, but one didn't even have to come in the courtroom because they had recently moved out of Canton, so were no longer eligible to sit on the jury. So dodged a bullet on that one. That juror did, but the pool that actually came in was 47. So they did seat 3 jurors yesterday, but they also lost one for personal reasons. So that's bringing our grand total right now to 12. So we have 12 jurors. We need 4 more. After court yesterday, I'm going to go ahead and add our feed so that we can be watching, waiting impatiently. They had 47 come in yesterday. They had 45 had heard of the case. 27 had formed an opinion. And then after court yesterday, Karen Reed talked to the reporters outside. She said that they are expecting opening statements to start on Tuesday. So we have Wednesday, Thursday, Friday, and Monday to seat the remaining 4 jurors. They're expecting to start openings on Tuesday. So as of Tuesday, cancel all plans for everything you have going on for the next 2 months. We're going to be here at jury duty. I'm going to unmute this now. I've been eavesdropping and listening to them a little bit this morning. But
I don't even look anymore.
They've been chatty this morning. They've been chatty. Good morning. Good morning. Can y'all hear them chatting? Make sure I've got all my audio set up right. Banging around in there. Make sure y'all can hear it. And make sure y'all can hear me. They're dialing now.
Welcome to Zoom for Government. Enter meeting.
Love a hot mic.
Participant ID. Please enter the meeting.
Phoning a friend.
Please mute. Don't listen.
You have joined the meeting as an attendee and will be muted.
It's really loud. It's really, really loud. We'll undo the audio when they stop dialing and all of that. Okay, so we have 4 more that we need to seat. 4 more. And if they seat, oh, here we go. If they seat those 4, oh, we're just going to the clock.
Here's the list that we're doing.
If they go to, if they seat those before, I don't know. I have not heard yet if they're going to do free my boy Billy Tibbetts. Oh my gosh, that's what I think of every time I hear that Zoom sound now. Free my boy Billy Tibbetts. First trial stuff. So if they seat those four, it's not clear yet if they're going to do it. Like, there's still some motions that have not been decided yet. So I don't know if they're going to, have any final hearing on those, or if she's just going to issue her rulings. Yes, Alan Jackson is supposed to be doing the openings this time. Last time it was Yannetti. So this time it's going to be Jackson. So we'll see. We'll see. Yes, we can do another poll on how long it's going to take. Start a poll. Okay. When do you think jury selection will be done? All right. We'll say today, tomorrow, Friday, or Monday. All right. So we'll see. Also, yesterday, Karen Reed said after court, she was talking to, everybody's following her around with the cameras and stuff. And she said that the defense has used 11 of their challenges and they get 16, and that the prosecution has used 12. So the challenges are basically they can strike any juror without having to give a reason. So and each side gets 16. So the defense, she said, has used 11 of theirs and the prosecution has used 12. Now, after those 16 are all used up, then they have to have a specific reason to strike a juror. Like, for example, bias or, conflict or already formed an opinion, that type of thing. So they've got 5 more for the defense, and they've got 4 more to use for the prosecution. So moving right along. Where's the fan? They took our only fan, and now they're giving us a clock. But the clock kind of puts you to sleep, so I can't watch it, or like hypnotizes you. I'm late. I keep expecting 13 juror notifications. I know. You got to come on over to our new neighborhood. All they said, the reason that we lost the one, all they said was personal reasons. So they didn't really tell us why. They just said personal reasons. So I'm not sure. Married, chat daddy, discussion father, proof of life. He is around here somewhere. We sat out on the back porch this morning with the dogs for a little bit before we both had to get to work. So he's around here somewhere, I think. The lonely clock. Doesn't it, like, watching it tick? I see now why people say that hypnotizes you, because it really does kind of, you get caught up watching it. This is not something I would want to be hypnotized for, because there's no telling what happens in Dedham Courthouse. Do we know how many they brought today? Not yet. We should be hearing all of that pretty soon. So when they come in, the court clerk has the official numbers, but when they come in, the reporters that are in the courtroom already start counting them to see how many there are. So we usually hear pretty quickly. And I am stalking all of the, local reporters, but stalking in a good way. So today is supposed to be a short day, though, apparently. So I have sources in the courtroom saying that Yannetti said today that it's going to be a short day. So we'll see. We'll see how many they have. Right now in the poll, most people are thinking that the majority of you are thinking that we're going to be done by Friday. So we'll see. I feel like they lose members every time they add some. Did that happen the first trial? Yeah, there's always going to be a couple situationships where, something comes up or somebody ends up not being able to do it for whatever reason. So it's not that uncommon, especially in a trial this long. See, if this were a trial that were like a week long or 2 weeks long, it would be a lot different. But you run into a lot more issues when you have a high profile trial and when you have a trial that is going to last so long. So, hello, Nikki. Brady, are you really Mrs. Chet? I really am. Yep, I did it. Never say never, I suppose. Good morning. Good morning. Hello, distant day 7. Day 7. I saw a report that AJ was planning opening statements next Tuesday. Yes, that is the plan. As of now, that is the plan. AJ will be doing openings. Alan Jackson will be doing openings instead of Yannetti this time. And right now, they are expected to start on Tuesday. So we'll see what else comes from this. The jury so far is 12. We are still split down the middle with 6 men and 6 women. So with your new gig here, are you still going to be doing the podcast? Yes, I am still going to be doing the podcast. So you will still get, it'll be just like last year where I streamed all day and then worked all night so that you could still get the podcast episodes. So I will definitely still be doing the podcast. The release date is going to turn to Fridays, possibly Saturdays, so that I can try to get most of the week in there. So that way I can, instead of releasing on Wednesdays or Thursdays like I've been doing most of the time, I'm going to be changing that up to Fridays or Saturdays so that I can try to get all of the week's drama in there and recap everything. And then once the trial is over, we'll go back to releasing midweek. Why the change in who is giving opening statements? I don't know. I think, lawyers have different strategies for different things. I think the first time, we kind of speculated on why we thought, one would do it over the other. I think that, excuse me, I think that having Yannetti do it was kind of like the hometown guy, doing it. And, AJ is a very good storyteller. He's very engaging. So maybe they're going to, let him do it this time. I think they're both great attorneys. So we'll see how different it is. They all work on it together and then go over it together. And then one of them delivers it. So we will see. So yes, Alan Jackson is going to be, that is what we are told after court yesterday by Karen Reed, that Alan Jackson is going to be doing it this time. So let's see what else. What else is happening? Let me see if I can get any more. Did you see that the Canton Select Board results came in? John Connolly is no longer on the Canton Select Board. He's been voted out, and Susan Harrington has been voted in his place. So thank you very much. So yesterday we went and picked up the other one. I have another band that we added to the top because my ring's a little bit too big. So we added a band to the top that I could size down to keep it on. So, because I didn't want to have to give it to anybody to size it. I was scared to turn it over to anybody. Good morning. Good morning. Y'all don't forget to vote. We're voting to see, the poll right now is how long until we get a jury seated. Most people right now are thinking that it's going to be Friday. That's what the majority of you are voting as of now. We still need 4 more jurors. 4 more. And right now, we're split right down the middle. Okay, David Bynick. I told y'all I'm stalking the reporters that are inside. So he posted an update. Let's see what he says. Karen Reed and her defense lawyers are gathered in the courtroom. Reed is showing some poster-sized pictures to people. We can't see what's on the pictures. Defense attorney Robert Alessi is chatting with the court reporter. No sign of the prosecutors yet. There's a pile of about a dozen pencils waiting at the spot where Special Prosecutor Hank Brennan normally sits. He loves his pencils. Let's see. The court clerk told us at the end of yesterday that the current jury stands at 12 of the 16 that are needed. He said a possible 13th juror would return today. 13 jurors in the house. And Reed told reporters that opening statements are tentatively scheduled for next Tuesday. So that's the inside scoop as of right this moment. And I am going to continue stalking. Judge added to the number she wanted late in the game last year. And that there is a chance that could happen again, especially with this being such a long, such a long trial. It's probably smart to have some extra alternates. Checking for anybody else that's given us any so Ted Daniel tweeted, I guess the cooler that they bring in with the lunch, he says, it has Trader Joe's chicken breast, plant-based cheese, unsweetened applesauce, and Alyssa oatmeal cookies. And that's it's not a Yeti cooler, it's a Yaneti cooler. That's what he says. Funny. Paul, hello. Good to see you. Brady, love listening to podcasts. Thank you so much. Thank you. Jury selection isn't broadcast. They come on at the very beginning and they do their whole spiel. So we listen in so that we can get the numbers live in real time, see what's happening, and then we call it a day. But starting next week, we're going to be here. We're going to live here now. We are going to live here now for about 2 months. Should I change my handle to Yaneti's cooler? It's Alessi's Yaneti. He's a very healthy guy. Yeah, he said that David Yaneti is once again renting space in his namesake in the cooler. And Alessi says that his healthy eating is rubbing off on him. That's funny. Funny. Who put him in charge of snacks? It's those healthy snacks. Those healthy snacks. Did any of you watch Laurie Vallow Daybell yesterday? I did get to watch the opening statement that she did when she said the evidence will show about 11 times. I did see that, but I haven't got to see anything else of it yet. I've been really crazy busy. Have y'all been watching it? I heard she's not doing as bad as some have done, but as the trial goes on, I have a feeling it's going to get a lot worse. But I did see her openings. It's so bad. You know, I was explaining this to Chat Daddy yesterday. I was telling him, because I was talking to him about it, and I was saying, he was like, why would she represent herself? And I was like, what's the worst that could happen? Because she wants everybody to hear her side of the story. She's already serving a life sentence. She's not going anywhere. Like, she's going to be in prison for the rest of her life. So by being her own attorney here, she gets to say whatever she wants, give her side of the story. And what's the worst that could happen? I think that for her, and this is just me speculating, but I think that for her, this is probably just her chance to say what she wants to say and get out her side of things. But not a Lori Vallow fan. Not a Lori Vallow fan. When all of that's the thing, is when all of the facts come out and all of those texts and everything, I don't know how she's going, like, how's she going to cross-examine that? Like, you know, how are you going to explain that? Yeah, and she's also the only one left alive to tell that story. What's creepy is when she is cross-examining the detective and you know she was there and knows what happened. I'm sending all the thoughts and good vibes to Kay and Larry, because I can't imagine how hard it is for them to be in that courtroom and having to listen to her cross-examine and stuff. I can't imagine. So sending all the good thoughts and well wishes to them, because I know that's got to be tough. Good morning. Good morning. Come on in. Come on. Sorry, I had my notifications on for my email and forgot. Turn that off. Good morning. And she gets to wear human clothes for a bit, but she does have a shock vest on. Isn't that crazy? That's kind of crazy. Remember the shock vest that, for those of you who watched Bryce Rhodes with me, he was awful. And I was secretly. I had muted the sound from the court. I just turned it back on because they should be starting in just a moment. Good morning. Good morning. Can you see her trying to run from the courtroom? That's a funny visual. Oh. I saw somebody post a clip from, remember when she's on the body cam saying something about how she's not going to get invited to pool parties anymore or something after all of this? I heard somebody posted a clip yesterday when the detective is on the stand talking about that. And brings that up. You can hear her at the defense table saying, "What?" All right, 58 people in the jury pool. 58 people in the jury pool today. A little bit more than yesterday.
I think Twitter makes you automatically follow everyone on Instagram. Because you hit my feed and I nearly had a stroke. I was like, there's no way I have.
Yep, Gerald was representing himself again for his appeal.
was actually.
Beautiful sunny day here in Beantown. 32 degrees. It's 32 degrees there. $32.
No way.
That's crazy.
Did a good job, obviously.
Like we have a high of 80 today. That's spring in New England. Oh, my old bones hurt just thinking about that.
All right, great. Yeah, yeah.
No, he's doing his appeal.
That's him.
Okay, yes, but in a month when it's really nice there, it's going to be so hot here you can't go outside. So right now it's great. It'll be scorching in a month or two. It's 34 in Columbus, Ohio. You know, I lived in like Dayton, Cincinnati area for 6 years. Oh, the winters were so long. Last Thursday it was 70, and the day after it was 40.
Like kids our age follow police departments. Like,
That's crazy.
I follow them on Twitter because I'm nosy. I do.
no, I know.
I want to know what happened.
My spirit animal. I'm nosy too.
So it's not the post, it's the guy. So it's the guy, but then
He interacts with
he
him.
also
All right, I'm going to mute them so we're not just listening to their personal conversations. Let's get the vote in. I'm about to change the poll to see how many you think are going to be seated today. This is what the poll that we have up right now is. When do you think that it's going to be, when it's going to be over, or when we're going to get the full jury seated. I'm about to do one for how many you think we'll get today. Because now that we know that there's 58 in the jury pool today, we'll do I'm going to end this poll. All right. So the majority of you think, 45% of you think that we will be done Friday, 32% think tomorrow, 12% Monday, and 9% today. We are at 12 now, so we need 4 more. All right, start a poll. How many jurors will we get today? Okay, we'll go with 0, 1, 2, 3 to 4. Start poll. There we go. Do we know how many challenges each side has left? Yes. As of yesterday, the defense has used 11 of their challenges, so they have 5 left, and the prosecution has used 12 of theirs, so they have 4 left. We live here now. It'll be another week. Watch. Oh, here we go.
You are unmuted.
Was not open in NC. 22-117 Commonwealth versus Karen Reed. Can I have counsel identify themselves, please?
Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Attorney McLaughlin went downstairs. I had left something behind, but she's here.
So we will wait for, I was told counsel wants to see me, so we'll wait for her to come back up before we stop it. We can do the introductions. Thank you. Good morning, Mr. Jackson. Good morning, Ms. Little.
Good morning, Your Honor. Robert Leslie on behalf of
Good morning, Mr. Lessie. Good morning, Ms. Gianetti. Good Good morning, Ms. George. Good morning, Ms. Reed. All right. Ms. McLaughlin, we were not going to start without you. The introductions take a minute or so, so we did that. So I was told council wants to see me, and it should probably be at sidebar.
Sidebar. Sidebar. Lori says, oh, Lori thinks they're going to lose another juror. Maybe. Maybe. Sidebar. Good morning. Good morning. Oh, I heard screenshots. Maybe we are about to lose a juror. Another one bites the dust. Possible. That's from their Zoom. They have the Zoom. It does that when they're at sidebar muted. They may be turning over Facebook data on jurors. Remember, they had that motion where the Commonwealth had asked if they can search for them on social media and do some research on them. So they're allowed to do that. So could be. I think they said that one non-attorney can search.
So what I'm going to do is this is something that's going to take some time. Why don't we bring the jurors over? You all can look at it. We can discuss it at a later point because it doesn't concern anything we need to address right now. And next time, if there is something that comes up like this, please let the other side know. That would have cut out on all of this time.
All right, to the board, please.
At some point, you can give it to Mr. McDermott, maybe somebody can make the copy.
Maybe seated.
What a mess. There's our only fan. She gets onto the defense a lot. A lot. I wish that she had that same energy for both sides. Like, I loved Judge Sisitsky, how like he gave it to Brennan for lying in court, but he also had that same energy for defense. I like a judge that's fair on both sides. I can appreciate that. So I wish.
Or do you want to be on?
I wish it were like that with this one. How could Bev be on this case when her brother represented Chris Albert? In my opinion, there's perceived bias. The defense did try to, they filed a motion and did try to get her to recuse herself, but she wouldn't. So. Sisitsky is awesome. Yeah, I liked him. He's very like to the point, focused on what's right, what's, you know, I loved that. And he's very matter of fact. Just, I loved that. And he's fair. I agree. He's fair. You know what other judge I really liked? Oh gosh, I can't remember her name. From Fami, the Thomas Randolph trial. What was her name? I loved her too. And she talked in like 1.5 speed, which I can appreciate and love. What was her name? Fami, the Fami trial. What was her name? I can't remember. I'd have to look it up. But can you imagine how this case would go and how potentially how much smoother it would go with a judge like Sisitsky? I loved the Murdoch judge too. It said that Miss Little was showing Brennan something on her phone after the sidebar. Frying the jury. I loved that. It is a beautiful courtroom ceiling. Judge Darrow, yeah, she has the patience of a saint. God save the Commonwealth. I love that. The hear ye, and the God save the Commonwealth. Best part of the day. The Chaconas judge was awesome too. Yeah. Oops. Just moving myself around. Who was, remember the judge in California for
Please rise.
Amy Hartwick with the red
All
microphone.
persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. The court is now open. Jurors remain standing. All the parties may be seated.
Jurors, can I have each of you raise your right hand? You solemnly swear to give true answers to such questions as should be put forth to you by the court, so help you God. Thank you. You can have a seat. May I call the case, Your Honor?
Please.
This is 2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, please?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Wiley for the Commonwealth. Morning.
Good morning, Mr. Lally.
Morning, Your Honor. Hank Brennan for the
Good
Commonwealth.
morning, Mr. Brennan. Good morning, Mr. Jackson. Good morning, Ms. Little.
Good morning, Your Honor. Robert Leslie on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Kennedy, Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. Good morning, jurors. My name's Beverly Canoni. I'm a judge of this court, and I want to give you some idea on how we think your day would shape up. First, I want to thank you for your patience this morning. It sometimes takes a while to get over here with paperwork, and sometimes I meet with the lawyers beforehand, so we tried to do it as quickly as possible. We do appreciate your patience. We also thank you for being here. Jury duty is certainly one of the most important civic duties we have, and we know that it's an inconvenience, but we do appreciate that you're here, ready, willing, and able to serve if called upon to do so. You've heard that we're impaneling a criminal case, Commonwealth versus Karen Reed. The Commonwealth alleges that at
58.
approximately 6 a.m. on the morning of January 29th, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers also identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was later pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene, while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations, and she is presumed to be innocent and has pled not guilty. Now, Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death. I will describe these crimes in greater detail at the end of the case when I teach the jury the law. But briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld. In order to determine your eligibility to serve on this case, I'm going to ask questions to you all as a group, and then I am going to ask you to fill out a supplemental questionnaire. We have found that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than just being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up on your answers to those questions and to my questions. I want to thank you in advance for your patience as we go through this process. As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the empanelment procedure. If you're not selected for jury service on this case, please don't take it personally. Don't think that somehow we think you're not a fair person. It's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for a different trial in a different case. In a few minutes, I will pose a number of questions to you as a group, and you've taken an oath that requires you to truthfully answer these questions and all questions posed to you. I'm not going to ask you to take your juror cards out yet. I'll ask you to do that as it gets closer. But if your answer is yes to any question that I have, I'll ask you to raise your hand and hold up your juror card in the air with the numbers facing out so that the court officers can read the number from the card. The fact that you answer yes to one of my questions does not mean that you are automatically disqualified from jury service. It simply means that there are matters that the lawyers and I need to discuss with you at sidebar. If you find a question that I asked to be overly intrusive, you can elect to answer that question at sidebar as well. I will have additional questions for you which relate to issues that may be raised in this trial and are designed to give us information regarding your ability to serve as a fair and impartial juror. And the lawyers are permitted to ask you questions for the same purpose. This is not a test. There is no right or wrong answer. We're simply looking for your best and honest answer. Now I'm going to have the lawyers introduce themselves to you, and I'm going to ask defense counsel to introduce their client. Starting with the Commonwealth, please.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me, I'd like to introduce my two colleagues.
Good morning, my name is Laura McLaughlin. I'm an Assistant District Attorney representing communities in Norfolk County. Thank you for being here.
Good morning. My name is Adam Lally, Assistant District Attorney with the Norfolk County District Attorney's Office. I want to thank you all for your time and attention being here.
Thank you. For the defendant, please.
Good morning, folks. My name is Alan Jackson. To my right is Karen Reed. I'm honored and privileged along with my colleagues to represent her during the course of this hearing.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I also have the honor of representing Ms. Reed.
Good morning. My name is Robert Alessi. Thank you very much for taking the time to be here today. It is also my honor and privilege to be representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have offices in Boston and right here in Dedham. It's truly my pleasure and privilege to represent Karen Reed.
Good morning. My name is Victoria George, and I also have the privilege of representing Ms. Reed.
Good morning, I'm Karen Reed. Thank you for being here.
All right, thank you all. Jurors, I'm about to read you a witness list. It's very long. It doesn't mean
Very
that
long.
all of the people on this witness list will be called as witnesses at trial, but you may hear their names mentioned during the trial. So it's important that you listen to the names, because when I ask you a series of questions, the first question I'm going to ask you is whether you know any of the jurors, of the witnesses. So the list is long. It's in alphabetical order by first name. So Aidan Kearney from Jefferson, Mass. Dr. Isaac Wolf from South Miami, Florida. Alfred Lopalato from Canton. Allison McCabe, Canton. Andre Porto from the Mass State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler, who is a PhD.
Okay, I'm going to turn this down for a minute because we've heard this list a million times. Did y'all see that the forensic pathologist that Karen Reed's defense has added to their witness list this time? Did you see that she actually testified in that other trial that's going on in Norfolk County this week? She testified yesterday in that trial. She was testifying by Zoom, but I got to watch a couple minutes of it, but I didn't get to see the whole thing. But she seemed really, you know how some experts, you can tell that they're really smart, but they don't relay information well. She seemed like she was one that actually relayed information well. So she'll be interesting to hear her perspective on everything. I haven't got to see a whole lot of that other trial. There have been some crossovers with, some stuff happening with that one. A couple of people have gone in to sit in on that trial, while they're there for jury selection for this one. So I've heard a little bit about it, but I haven't got to see a whole lot of it. But yeah, she's the new forensic pathologist that the defense hired, and she testified yesterday. So I thought that was interesting. Yes, the doctor. Where'd that comment just go? Yes, that one. The doctor. How do you say it? Twerk. Surely it's not twerk. Twerk. I don't know how I'm saying it.
Ian Whiffen from Vienna, Virginia.
Turk.
Dr. Irene Scorti-Bello from the Office of the Chief Medical Examiner here in Massachusetts. James Crosby, who is a PhD from Jacksonville, Florida. Janet Reed from Dighton. Jason Becker from the Canton Fire Department. Jean DeMoulis from Canton. Jennifer McCabe, Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe Sr. from Braintree. Judson Welcher, who's a PhD from a company called Aperture LLC. Julie Albert, Canton. Julie Nagel, Canton. Dr. Justin Rice from South Weymouth. There are 2 juveniles from Canton, the first of whom's initials are KF and the second PF. Caitlin Boudreau from Raynham. Karina Kolakithis from Canton. Katie Camerano from Canton. Katie McLaughlin, the Canton Fire Department. The keeper of the records for Ring from Hawthorne, California. Kerry Curran, Canton. Kerry Roberts, Canton. Kevin Albert, Canton. Kevin O'Hara from the Mass State Police. Lance Mello from the State Police Crime Lab. Laura Sullivan from Pembroke. Laurie Cahill, Worcester. Leslie Pearlstein from Canton. Lieutenant Michael Lenk from the Canton Police Department. Louis Justress from Canton. Lieutenant Brian Tully, Mass State Police. Lieutenant John Fanning, Mass State Police. Lieutenant Paul Gallagher, Canton Police. Maggie Gaffney, Bonita Springs, Florida. Mark Lopalato from Canton. Margaret O'Keefe, Canton. Marietta Sullivan from Pembroke. Mary Souza, Dighton. Matthew Amory, Canton. Matthew DeSogra, Charlotte, North Carolina. Matthew Erickson, Grosse Pointe Farms, Michigan. Matthew Kelly from the Canton Fire Department. Matthew Kelsch from the FBI. Matthew McCabe, Canton. Maureen Harnett, State Police Crime Lab. Megan Mariani, New York, New York. Michael Camerano, Canton. Michael Easter, Los Angeles. Michael Trotta, Canton Public Works. Michael Wagner from Foxborough. Mike Maroli, Bridgewater. Mike Rushworth from Thompson Station, Tennessee. Natalie Wyweek Berschneider from San Marino, California. Nathan Reed, Raynham. Nicholas Bradford, Lorton, Virginia. Nicholas Curran, West Roxbury. Nicholas Kolakithis, Canton. Nicole Albert, Norwood. Norfolk County District Attorney Michael Morrissey. Officer Kelly Deaver from the Boston Police. Officer Nicholas Barrows from the Dighton Police Department. Patrick Haggerty, Somerset. Paul Makowski, Melrose. Paul O'Keefe.
The Sullivan sisters are still on the witness list because Brendan has said that he does not plan on calling them, but he will call them if the door has opened. So keep in mind, everybody on the witness list is a potential witness. The witness list is always a lot bigger than who they actually call. They put everybody who is a potential witness on there, but not all of them get called. They did the same thing last year too.
Police Department. Sergeant Paul DiGiambattistro from Canton Police Department. Sergeant Yuri Buchanan from the Massachusetts State Police. Shannon Burgess, South Lake, Texas. Cheryl Waugh, Canton. Sophie Herzan, Mass State Police Crime Lab. Stephanie Devlin, also from the Crime Lab. Stephen Mullaney, Canton Police Department. Steve Nelson, Norfolk DA's office. Stephen Bernstein, who is a keeper of the records from Stoughton. Stephen Ridge, Boston Police. Stephen Seraph, Canton Police. Stephen Scanlon from West Roxbury. Terry Kuhn from Davis, California. Tess Chart from Lorton, Virginia. Thomas Beatty, Canton. Thomas Kelleher, Canton. Thomas Martin, Weymouth. Timothy Nuttall, Canton Fire Department. Tristan Morris from Easton. The following are Massachusetts State Police troopers. Trooper Connor Keith, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Koskowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark. Wendell Robery from Canton, William Reed from North Dighton. Those are the witnesses that may testify, or at least you will hear their names. So it's a long list. This case is going to take a while to try. We're in the process of impaneling a jury. We don't know how much longer that will take. Once we get a jury, the lawyers tell me that their best estimate is that the case will take 6 to 8 weeks for the evidence. Once the evidence is in, the lawyers give their closing arguments. I instruct the jury on the law, and then the jury deliberates for as long as they need to deliberate. So that's our schedule. It is the best estimate we can give you folks. I can tell you that during trial, every single day before we recess for the day, I let the jury know whether we are on track, ahead of schedule, or behind schedule. And I have never once had to say we were behind schedule. So we understand how important your time is to you, and we can be as efficient as we can possibly be. There are a few days sprinkled in that we will be out during that, and a few half days where we will go until 1 o'clock or so. That's the schedule. The way the days look is we will start at 9 o'clock in the morning. We will take a break at around 11 for a 15 or 20-minute recess, and then lunch will be brought in so that you don't have to walk down to Dedham and come back. Again, trying to be efficient with the time, and that'll be about 40, 45 minutes during the day, and then we'll go until about 4 o'clock every day. That's the schedule that we anticipate. And again, it is a good faith estimate. So now it might help if I give you a preview about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a brief summary of some of the important legal principles that will govern this trial. First, and most basically, Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is simply a piece of paper. It just makes an accusation. It's a formal manner in bringing an accused person from to trial in the Superior Court. But it's only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt and to a moral certainty. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove his or her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all of the evidence. So a similarly important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the government, "You accuse me, now you prove it, and prove it beyond a reasonable doubt and to a moral certainty. I do not have to say a word." A defendant's decision whether or not to testify has nothing to do with the question of whether he or she is guilty. The jury must not consider it in any way and cannot discuss it during deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before the jury in the case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair
They've been saying
decisions.
16.
All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to start making your mind up before then. Third, You should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the
Yes.
law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of this case, I will remind you of these strategies and ask you to focus on the evidence instead of on any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of this is confusing at this early stage. You'll certainly be in a better position to understand this at the end of the case when you have heard the evidence and I can explain the law to you. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law on this case. You don't necessarily have to agree with the law, but all jurors will have to apply the law as I describe it to you. So for jury selection, it's important to know if any of you might have some doubts whether you can accept and follow these legal principles. Now I ask you to take out your juror cards, please, because I'm going to ask you a series of questions.
All right, here we go. Ready to count?
So if your answer is yes to any of these questions, please raise your hand. But before we begin, I understand that sometimes jurors don't fill out the juror questionnaires that are sent to you in a complete manner. Sometimes we're in a hurry to get those forms back in, or we might think our situation doesn't apply to the question that's being asked. Also, sometimes people forget to write in whether they were a witness in a case, a criminal defendant, a juror, or a party in some case. So if you realize now, or before you come up to us at sidebar, that there's some parts of your questionnaire that aren't complete, please let us know. And if we see things like you didn't fill in how old you are, we'll ask you, or your prior employment or your current employment if you're currently working, things like that. So we will ask you those, but if you know in advance, please let us know. All right, first question. Do any of you folks know, or any close personal friend or family member know, or have you had any prior dealings with any of the witnesses? Sure. Do you, a close personal friend or family member, know, or have you had any prior dealings with any of the witnesses whose names I read?
Juror number 835, juror number 852, juror number 803.
Juror number 802. Juror number 793.
Thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or the Norfolk County District Attorney's Office? I see no affirmative response. Oh, I'm sorry.
Juror 802.
Thank you. Do you, a close personal friend or family member, have any financial or other personal interest whatsoever in this case or its outcome?
We've only heard that one time. There's only
I
been
see
one.
no affirmative responses. Please raise your hand if you have seen, heard, or talked about this case.
Here we go. This one's always a lot.
Juror number 806, juror 781. Please hold your cards high. Thank you. And you're facing me correctly. Thank you. Juror 808. Juror 784, juror 786, juror 846, juror 785, juror 827, juror 842, 792, 826, 788, 836, 851, 793,
Your 780, your 822, your 853, your 819, your 824, your 798, your 794, your 795, your 802, your 812.
there are 832, 839, 840, 833, 790, 829, 796, 834, 855, 797, 791, 815, 835, 814, 843, 852, 804, 807, 805, 844, 817, 809, 803, and 810.
All right, thank you. Please raise your hand if you have expressed or formed any opinion with respect to this case.
Juror 806, juror 808, juror 846, juror 842, 792, 826, 819, 856, 853, 822, and 780. 832, 833, 790, 829, 796, 843, 835, 815, 791, 856, 852, 804, 844, 817, 809, and 803.
All right. Thank you. Are any of you aware of any bias or prejudice that you may have in regard to this case or in favor of or against either of the parties? If so, please raise your hand.
806, 856, 833, 790, 829, 791, 815, 835, 852, 803, 809, and 817.
Okay. Thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical belief that might interfere with your ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? Please raise your hand.
808, 846, 856, 794, 796, and 811.
Thank you. Would any of you folks have any difficulty following the important constitutional principles that I explained to you earlier? First, that the burden of proof rests entirely on the Commonwealth. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden to do anything. She doesn't have to testify. She doesn't have to present any evidence. In fact, her lawyers don't even need to ask a single question. Is there anyone who would have any difficulty following those very important constitutional principles? I see no affirmative responses. I can tell you folks that after every trial, I talk to the jurors. And though some of them may have not been looking forward to jury duty, every jury that I talk to, people tell me that they have found it to be a very interesting experience, and many times they tell me it was also a rewarding experience. But I do understand that for some of you, sitting on this jury will be a substantial hardship. And let me tell you what I mean by that. Every civic duty we have causes us to be inconvenienced. This is something much greater. It means that I excuse you for something that's personal to you, but the person sitting next to you has to step in and take your place. I usually think of it in terms of you have surgery or airline tickets scheduled for the duration that we will be in trial. But I will hear from those who believe they have a substantial hardship. If you think that's you, please raise your hand.
This is the last one.
785, 846, 848, 878, 851, 780, 822, 826, 853, 802, 832, 833, 790, 829, 843, 828, 797, 852, 804, 817, and 803.
Okay. In a minute, I'm going to leave the bench to give you a chance to fill out those supplemental questionnaires. As you do so, I'd ask that you not talk to anybody about them or share your thoughts or your information or any questions, comments, or concerns that you might have about jury duty, either generally or specifically about this case. If you have any concerns, you can bring that to my attention when I see you at sidebar. So, thank you.
All rise to the court, please.
Alrighty. So what I got was 49 out of 58 that had heard of the case, 27 that had formed an opinion,
Thank you. Please be seated.
12 that had 12 that had some kind of bias, and 21 that had hardship, and 5 that knew the witness. Is that what y'all got? Good morning. Good morning. Better late than never. Let's see. Some of the reporters are posting their numbers too. Let's see if ours 49, 27, 12, and 21. Yep, that's what I got. Okay. So 49 out of 58 that have heard about it is actually less than what it has been recently. It's been really high recently. That's only 84%, which is still really high, you know, under normal circumstances. But I'm about to take a picture of what's happening under my desk right now. So I can show you. I have not got Lucy Cam set up yet because she doesn't have like one spot where she really stays right now, but I did put her bed under here, and so she's sleeping. So look at, can you see? Look at little Lucy. Isn't she cute? She's not laying very ladylike right now, but it's still cute. She's still cute. And then Tinsley, I'll show you Tinsley too. Tinsley's over here. She's on the other side. She's right here. There's Tinsley. And, and hold on, there's more. But wait, there's more. And here's Emmy and Ollie. So I've got like a whole zoo up in my office with me right now, which is why I haven't set up a Lucy cam, because they all swap spots all the time and they're all over the place. Scout, I don't think Scout's in here right now. Scout was outside earlier today. We had the whole zoo crew out on the back porch with us this morning. So it's like Zoo World up in here. All right. So we'll see how many they get today. This is day 7 and we have 12 so far and we need a total of 16 is what we're looking for. So I need a zoo cam before trial starts. I'll try to figure it out. I'll try to figure out how to make Lucy cam or zoo cam or whatever. I'll try to figure out how to logistically make that work, because they are all moving all the time. And there's a couch over there by the window. So Lucy will like to sit up on the top of that couch too and look out the window sometimes too. So, you know, we'll see. All right. So I will give y'all GoPros for all. Wouldn't that be fun and entertaining? Everybody would be watching that instead of what's going on in the trial. See, Lucy's already up now and on the move again. She doesn't stay in one spot long with all of her siblings around. Okay, so I will get maybe we can get a Leroy cam. What's the turtle's name? The turtle is Bruce Leroy. He is a Chinese box turtle, and his name is Bruce Leroy. He's the cutest. He's so sweet. Got a whole zoo up in here. All right, I will get the update out this afternoon once we find out the final numbers, and then I will see if we get any kind of update on what that was this morning. It seemed like social media something or other coming up, so I'll see if I can find out exactly what all that is, if they say anything about it, or if it's kept hush hush. So we'll see what we can find out about that. But I'll get the recap out for you at the end of the day. Maybe, just maybe, we will get a jury seated today. Just maybe. They sat 3 yesterday, right? And there were only 47 in the pool yesterday, and there's 58 today. So maybe we can get the last 4, maybe. But we might be losing one if that's what that was about this morning. So we'll see. We have 12 now because they gained 3 yesterday, but they lost 1 for personal reasons is all it said. So there are currently 12 and they're wanting us to get to 16. So that's all we got for now. I will try to keep y'all posted, and then we'll have the update at the end of the day, and then we'll kind of play it by ear, because if they do get a jury seated today, then we may not be here in the morning. If not, then we will be back live in the morning, 9 a.m. same time, same place, going through the same list again and listening. It is interesting to see how many are saying that they've heard of the case and how many are saying that, you know, they've already formed an opinion. I've never seen that many in a case that have. So, but you know, think about this. Like, think about this compared to like the OJ trial or something like that. That one is think about how high profile that one was and how long it took to seat a jury. And then the YSL trial, didn't it take like 9 months or something to seat a jury? Did I make that up? Is that a real number? Is that what it took? Y'all always know when I can't remember things. You always know. Almost a year for YSL. That's what I thought. Yeah. Like forever. Yeah. So at least it's not that, y'all. At least it's not that. So we should be hopefully starting on Tuesday. That's the latest word. So I will keep an eye out for any updates, and I will see y'all right back here tomorrow if there is still jury selection going on. If they get them all seated today, then maybe not. But otherwise, I will see y'all tomorrow. All right, y'all, take care and watch for the update later today.